I'm going to be discussing perhaps the most important rule of U.S. patent law that non-lawyers and inventors should be aware of. Hello and welcome. This is U.S. Patent Attorney Eric Kelly. What I will be discussing here is super important because if you do mess this up, you're just flat out prohibited, flat out barred from having or obtaining a valid U.S. patent. I'm going to be discussing a hard deadline of when you must absolutely file your patent application by, or you risk losing the ability to get a U.S. patent on your invention. An intent of this video is for you to understand the deadline around when you must file a patent application, as well as understanding the 1 year grace year period and how the 1 year grace year period gets triggered. Okay, let's get into this. Okay, so I'm going to be developing a timeline here with a number of different elements. So first, as you can see here, we have time moving from left to right. So time is advancing from left to right. Okay. Next, consider this first block here. And this is basically going to indicate the time it takes for the inventor or inventors to develop, design, engineer, and basically invent whatever the invention or product might be. So that's what this block represents right here. And that time, it could be minutes, hours, days, weeks, months, years, whatever. It's whatever time it takes to basically develop, design, and engineer that product or new invention, whatever it may be. Okay. And then generally at some point when that is at least largely or partially done, we're going to move on to the next element here in this timeline, which is going to be identifying here as the first date that the invention is made public. Okay. And this is also the point in time that triggers the start of what we call the 1 year grace year period, which we'll get into in a minute. But going back to this first date that the invention is made public, this can be all kinds of different things. This might be the first date that you sell the invention. This might be the first date that you offer to sell the invention. This could be the first date that you use the invention in public. This might be the first date that you showed the invention to friends. It might be the first date that a white paper or some kind of press release gets issued about the invention. This might be the first date that you release information about the invention on your website or on social media. Perhaps this is the first time this is the first date that your invention gets shown at a trade show. So basically it's the first time that you've made a public disclosure of your invention or a public availability of your invention. And notice I talked about how just showing this to your friends or using the invention in public can trigger this first date where you've made the invention public. And so that basically if you've shown it or used the invention to anyone, even if they don't know, or if you've used the invention in public but the public people around you don't know that still qualifies as triggering this first date that you've made the invention public. Okay. So keep all those different scenarios in mind. Any one of those could easily be one of those, the first date that you actually make this invention public, which then triggers the start of this 1 year grace period, right? So keep in mind, it's a very common scenario for an inventor after they've at least made a prototype or at least gone through some of the motions of designing it and engineering the invention. They generally show it to their friends or family. And that very often can be a point in time that triggers the start of this 1 year grace period. That could be the trigger or the start of the first date that you've made the invention public. So since essentially, if you share this invention or use the invention around friends or family, and those people have not signed a non-disclosure agreement with you, you're probably very likely triggering this first date where the invention has been made public. And that's a super common scenario. This happens all the time with inventors. And we see it quite regularly in television shows as well that play on this kind of concept that happens all the time. For example, I can think of in the sitcom New Girl when the suit invention gets shown, and that happened in season 4, episode 14, where it's basically this jumpsuit, or sweatsuit type material that's trying to mimic the look of a suit, of a formal suit. And that invention gets shown to friends and to a third party potential investor, and there's not necessarily any non-disclosure agreement involved there. So that could be a point in time where that invention is getting first triggered or first shown in public. Okay. And that starts the 1 year grace period rule. Another example from another sitcom was from Modern Family, season 6, episode 5, when the character Jay invents a sock dispenser and he shows the prototype basically to a stranger, a girl, a friend of his son, without her having signed a non-disclosure agreement. So again, that's going to be the first date that invention's been made public, and that's a point in time that's going to start the roll or start the movement of this 1 year grace period. Okay, so let's talk about the 1 year grace period. So the 1 year grace period just basically means that once there's been that initial first date where the invention has been made public, a first date where the invention was made publicly available or publicly disclosed, any one of those scenarios we talked about, it starts a period of 1 year where the patent application that discloses and describes that invention must absolutely be filed within 1 year of that initial date. Okay, and that's the 1 year grace period and the rule that we were trying to get across here. So once you've had that initial public date trigger, you have exactly 1 year in which to file your patent application. Okay, if you wait more than 1 year from when that initial first public date was, you're flat out barred, prohibited from obtaining or having a valid U.S. patent on whatever was publicly disclosed. Okay, so that's the real important rule that you need to be aware, because it's common for inventors to show off their invention at some point in time and then not necessarily keep track of when that date was, and perhaps they decide to file a patent application more than a year after that initial date. And if they do, they're flat out prohibited from obtaining a patent. So it's important to keep that rule in mind. So ideally, going back to this initial block here where it represents the time to develop, design, and engineer the product. Ideally, during that period of time, the invention should be kept confidential. It should be kept secret. So if you do want to share the invention or need to have others work on the invention, maybe you need some other engineering or 3D modeling work done or whatever, you really should be using non-disclosure agreements, NDAs, with any third parties you might be sharing the invention with at that point in time. Okay. And then this bracket right here, this indicates when you can file your patent application. So at any point in time, basically from here to here is when you could have your patent application filed. Okay. And then this bracket here indicates kind of when the preferred time would be to have your patent application filed, which is in general, you would prefer to file your patent application before the first date that the invention is made public. In other words, you prefer to have your patent application filed before you even trigger or start the 1 year grace period. And the reason for that is that once you do make the invention public, where it's that initial date where you've shown it off to someone in some shape or form, that can create potentially 3 other problems that aren't necessarily related to this deadline we're talking about here, but I will mention those 3 other problems that can be created when you do initially show off or publicly disclose your invention. So the first problem that can come up or arise once you've made the invention publicly known about, at least to one person who really hasn't signed a non-disclosure agreement with you, is that you can create a marketplace competitor. You could basically create someone who wants to go out into the marketplace and make and sell basically your invention. Okay, so by letting people know about your invention without being protected by a non-disclosure agreement or without having your patent application prepared and filed before that point in time happens when you share it, you're potentially allowing or creating or making an opportunity for there to be marketplace competitors. So that's the first problem. The second problem is that by you letting the cat out of the bag, so to speak, you can also have a situation where someone tries to file a patent application on your invention. Now that's not legally proper for someone to do because they're not the inventor. However, it does happen, and it would be a challenge for you to deal with that because it would basically be a legal dispute that you have to deal with. So that's the second potential issue that can happen once you've let the public know about your invention, is that someone else might try and file a patent application on that same invention, claiming that they invented it. And then third potential problem is that and this really gets back to what we are talking about here, is that you can kill a chance of getting your own patent if you wait too long between when you file your patent application and when you've made that initial public disclosure. Again, if you wait more than a year after you've made that initial public disclosure, you've basically killed your chance to get a patent on whatever it is you've invented and disclosed. Okay, to recap, we've been talking about basically the patent application filing deadlines and the hard deadline. So recapping in particular, the absolute one rule you really have to want to follow, or you need to follow, is that you absolutely have to have your patent application filed within 1 year of that first date that the invention's been made public. That's a hard deadline, hard rule, really no legal exceptions to that. And in addition to that particular rule, in terms of a couple of recommendations or preferences, ideally during that time period when you are developing, designing, and engineering the invention or whatever the product might be, you ideally want to keep the invention confidential and secret during that period of time, and you should use non-disclosure agreements, NDAs, with third parties to help achieve that goal. And then the other recommendation is that you actually do file your patent applications before you do have that first moment in time where you're making the invention publicly available, as that can help alleviate those 3 other problems that we discussed that can happen once you do make a public disclosure about your invention, such as creating marketplace competitors and creating patent application competitors. If you get your patent application filed before you've made a public disclosure about your invention, then you're in a better position to defend and alleviate and mitigate those potential problems. Okay. And to recap just some of the scenarios that can trigger the start of the 1-year grace period, these could be the first time that you've sold your invention, the first time that you've offered to sell your invention, the first time that you've used your invention around friends, family, or in public in general, whether people around you know or don't know that you're using the invention. This could be the first time that you've showed the invention to friends and or family. This could be the first time that you've issued a press release or some kind of white paper about the invention. This could be the first time that you've disclosed or showed, details about the invention on, your website or on social media. This could be the first time that you've demonstrated or showed the invention at a trade show. So any of these could be triggering events that could start the clock ticking down on that 1-year grace period. So keep those in mind. And this is not an exhaustive list of such scenarios, but this should give you a good idea of what kind of things can trigger the start of that 1-year grace period. And if the 1-year grace period gets triggered, then you absolutely must get a patent application filed within 1 year of that first initial date that the invention is made public. And finally, I am U.S. Patent Attorney Eric Kelly, and I do work with clients from all over the world as well as all over the United States. And this particular video is focused on the subject matter of patents and patent applications, in particular the filing deadline of when someone must get their patent application filed or they risk being forever barred from obtaining a U.S. patent. And as an intellectual property attorney, I also handle trademark matters and copyright matters, and trademarks deal with protecting brands, and copyrights address protecting creative subject matter such as videos and photos and things of that nature. And then lastly, you can see some contact information if you want to reach out to me regarding intellectual property matters. Thank you and bye-bye. Like and subscribe to help these intellectual property videos reach more people. And here's some additional videos of mine on intellectual property matters. Thank you.